Hey everyone. It's morning for me here. We've had a few things come down, so I'm gonna do two separate videos. One is for there's a couple of very short letters and an order, so I've called them multitudes of filings. And then I'll do the opposition to the spoliation sanctions as a separate thing because I think that's going to need more time. I have a bit of a croaky voice, so I apologise for that already. Okay. So this first letter, this is from Sony, attorneys for Sony, and it's regarding the, so Blake Lively is saying, you've filed all this stuff with your motion for summary judgment, and, there are 15 non-parties. We're going to express concern on their behalf. You've not given them notice about their own filings for them to, make arguments for them to remain under seal. And Sony is one of the parties that has stuff, documents and deposition transcript that has been filed by Wayfair as part of the motion for summary judgment, as Sony should actually expect to happen. The course of stuff is going to be filed with motions. So, Sony, dear Judge Lyman, we write on behalf of non-party Sony Pictures Entertainment to request an extension of time to file a motion to seal portions of deposition testimony and confidential documents produced by Sony and designated attorneys' eyes only, which defendant Wayfair Studios filed in connection with its motion for summary judgment. On November 18th, counsel for defendant Wayfair Studios informed Sony it had filed 26 documents produced by Sony and 34 pages of deposition testimony of a Sony witness as exhibits to its motion for summary judgment. All of the documents and testimony were designated confidential, and 4 documents were designated attorney's eyes only. Wayfair's counsel informed Sony the information had been conditionally filed under seal, and the deadline for Sony to request that the documents be permanently sealed is November 26th. On November 19th, Sony wrote to counsel for Wayfarer to inform counsel that Sony required additional time to review the documents and testimony, meet and confer with counsel for Wayfarer, and evaluate whether it was necessary to file a motion requesting that confidential and attorney's eyes only information be permanently sealed. Having received no response from Wayfair's counsel and given the impending deadline, we write on behalf of Sony to request such an extension from the court. We understand that plaintiff, Blake Lively, has sought an extension until December 8th to request that the judge permanently seal information filed in connection with Wayfair's motion for summary judgment. Sony respectfully requests the same or a similar extension of time. So this is not surprising. I mean, in terms of general notice, no, they weren't given a huge amount, but also when you look at what it is they specifically have to, be concerned with and review, is 26 documents and 34 pages of deposition testimony. This is the documents of stuff that they themselves have already produced, so they should know what it is. And 34 pages of deposition testimony. Well, I went through more than all of this, actually, more than the 26 pages of documents and more than the 34 pages of deposition testimony in about 3 hours of videos. I'm not quite sure why they need nearly 3 weeks to review it. However, they clearly they are asking for a similar extension to the one Blake Lively has asked for. Blake Lively has filed a lot more, so that may be why she has, in her case, asked for the length of time she has asked. I mean, again, her text messages, why does she need to review them? I don't understand why they need so much time, but it is what it is. Okay. I think we then got an order for an extension of time. Hold on, I'm just finding that. Okay, so this is on the back of Blake Lively's initial request, and it's one of the Judge Lyman's stamped orders or typed orders. And his order is at bottom in blue. The alternative proposal is adopted. So Blake Lively made two proposals basically and said, can you pick one of these? One was an extension for her to review the documents, and the other was to file a motion. I'm going to go up to it actually. Yeah. Oh yeah, here it is. Alternatively, in an effort to promote judicial economy and avoid piecemeal motion practice, Ms. Lively requests that the court extend and modify the timeline set forth in Rule 4B of Attachment A to Your Honour's individual rules and practices in connection with the motion. Specifically, Ms. Lively requests that the producing parties who may wish to move for a continued seal-in or redaction of any materials submitted in connection with the motion be permitted to file a single omnibus submission addressing all such requests within 1 week of the motion being fully briefed, or by December 19th. So what she's suggesting here is that all of herself and any of the third parties that she expressed such concern for all join with her and they file one omnibus motion for continued sealing or redaction. And Judge Lyman has basically said, right, okay, we are going to accept the alternative proposal. So the alternative proposal is adopted given the volume of relevant materials and the impracticability of resolving numerous motions in piecemeal fashion. Parties and non-parties are directed to file any motions for continued sealing of materials submitted in connection with the motions for summary judgment by December 19th. The court will act as expeditiously as possible under the circumstances and well before it decides the motion for summary judgment. The public will therefore be able to properly monitor the court's work prior to any such decision. So we have that. And then we had let's go here. We're bouncing around a bit today, so sorry. So there is an order for a hearing. So this is on Stephanie Jones's motion to compel production of documents from Katherine Case. Blake Lively filed a letter which just had me kind of tearing my hair out yesterday in the video. I was so annoyed by it. She filed a letter in support. Basically, I think it came across as, well, do you know what? I can't find evidence of my own smear campaign, so I'm going to help my pal Stephanie here. And if we can find evidence that, Melissa Nathan, who is one of the defendants that Blake Lively is accusing of smearing her, if we can find evidence of Melissa Nathan smeared Stephanie Jones, then maybe I can persuade the jury that, she's of the nature to have smeared me, on the balance of probabilities. Which is the standard for civil law. So in light of that, Judge Lyman then came out here and basically issued an order saying that the court will hold a video conference via Microsoft Teams to address the discovery dispute in the Jones action on Monday, November 24th at 3 p.m. That'll be at Eastern Time. The parties will be provided instructions for accessing the hearing via email. The court will post an audio-only dial-in number on the docket for the public and press to access a hearing. So we're going to get a dial-in hearing again. So yay, I get to ring America. I'm obviously not going to be recording that. That's against the rules, but I can summarize it and take notes and summarize it. So we'll get a hearing on that particular motion from Stephanie Jones, which is been supported by Blake Lively. Bless her. Okay, so we got then one more thing in relation actually to Stephanie Jones' motion to compel. Katie Case's attorneys filed a letter last night, which tickled me a little bit. It did make me laugh. Okay, and this is something that they have filed ahead of that conference on Monday. Dear Judge Lyman, on behalf of non-party Katherine Case, we respectfully respond to Miss Lively's untimely response to the Jones party's motion to compel, on which the court has now set a November 24th hearing, solely for the purpose of correcting the record. The central position of Miss Lively's submission rests on her counsel's assertion that Miss Case's potential production of additional records confirms that there are documents responsive to Miss Lively's document request that were improperly withheld. That averment is incorrect. I mean, at this point, is anyone surprised that Blake Lively has filed something with the court that is entirely misleading? So Lively has assumed, Jones is saying, look, I discovered during, deposition or discovery, I discovered further information that is relevant to my document production request. Blake Lively has piggybacked on and gone, I'm entitled to it too. But the request that she made, she does not necessarily make the same requests. Each party makes specific requests. We saw it with Isabella Ferrer, right, with the subpoena request, where Isabella Ferrer is saying, well, look, I've already responded to Blake Lively's, so why should I have to respond to Wayfarers? They can just go and get what I gave to Blake Lively from Blake Lively. But the actual subpoenas, Blake Lively's subpoena and then Wayfarer's subpoena, they were making different requests. Blake Lively was only asking for stuff, for documents that covered the period of filming, when Isabella Ferrer was filming. Wayfarer were asking for that, plus documents that covered the period of time during the marketing, when Isabella Ferrer was doing her press tour with Blake Lively, doing Book Bonanza, etc. Wayfarers, were asking for a different time period for different reasons, because Blake Lively is looking for any evidence of harassment or inappropriate behavior. Wayfarer are, looking to prove that Blake Lively turned Isabella Ferrer against them. and that they've alleged that happened during the promotion of the film. So they're entirely different time frames. Blake Lively won't have documents that Wayfarer need for the the period during the marketing of the film. And the same has happened here. Blake Lively has just assumed that she's entitled to the same documents that Jones is entitled to, and she's not. And actually, more so in this situation, because there was a hearing about it where Judge Lyman specifically ordered the search terms that Katie Case had to go away and, had to conduct a search and produce documents for Blake Lively. So the letter continues. Following extensive negotiations and motion practice, Ms. Case conducted a review based upon agreed search terms that were applied to agreed sources to a date range set by the court. Ms. Case produced all responsive non-privileged documents identified through that process. The assertion that because additional potentially responsive records may exist outside of those parameters, which is what Jones is alleging she's entitled to, Ms. Case somehow withheld records is thus untrue, as Ms. Lively's counsel knows or should know. We thank the court for its attention and consideration. As noted in our last submission, we will abide by the court's instructions on this application, just as we have done before. Very respectful, a bit snarky, amusing. Not surprising that Lively's tried to pull that one again. I am going to I'm going to wrap up here because I am going to then go and do a separate video for what could only be described as magnificent legal writing. That opposition, it made me really happy last night. So it's long though, it's 30 plus pages, so I am going to do it. It needs its own video, otherwise it's going to be too long. Okay, so I'll be back soon with the second video.